Hey, Ryan Brown here again, J. Ryan Brown Law, and I want to talk about something kind of unique that's going on in Coweta County Superior Court right now. And it's only unique because it's happening to a bunch of people at once. But the question is, what is an arrest order? Why do I have an arrest order? So there are a lot of people in Coweta right now who have been arrested on something, bonded out, got letters that they had court dates, and when they get to court are being told that they have an arrest order. And why the hell do I have an arrest order? That's so confusing, right? Well, let's talk about kind of the process that leads to that happening. So in Georgia, you can be arrested and charged with a crime, obviously by the police, and then released from custody when you post bond. Now, later on down the road, the formal charges are brought by either what's called an accusation or an indictment. An indictment comes from what is called a grand jury. I have blogs and videos about that available for you as well. But a grand jury, which is a meeting between around 20 citizens of the county and the prosecutors and the cops. We're not allowed to go unless in very special circumstances. They get together, and that group of people, at the behest of the prosecutors, can add charges. So you could be arrested for misdemeanor battery, bond out on that, and then the DA's office, the cops, and the grand jury could get in convene a grand jury. The prosecutors could recommend and suggest enhanced charges, felony charges, or some different kind of charges. And the grand jury can issue an indictment on new charges without you ever being arrested on it again. And when that happens, you technically have new, possibly felony charges, which means that you're going to have to be fingerprinted and booked on those new charges. Now, this comes as a surprise to many people because they get this arraignment notice in the mail. They show up to court and they had no idea that there was an arrest order. There was no way for them to even know. And basically, when the grand jury adds those charges, a Superior Court judge will sign an arrest order ordering that the sheriff take the defendant into custody and fingerprint them and book them on the new charges. Many times, this can require a new bond to be posted and to be set on the new charges. So it is a unique and complicated situation that can be very confusing. A telltale sign is when you get an arraignment notice in the mail and it's got charges listed on it that are more serious or different from what you were arrested on at the beginning. It is very important in a situation like that to have your lawyer with you when you go to arraignment or before arraignment so that they can be prepared to try to get you out on bond as soon as possible. It's a tricky thing that happens. I don't necessarily think it's fair, but life's not fair, and certainly the deck is often stacked against criminal defendants, and that's why we're here to help try to make that deck more fair. So just be conscious. That's what an arrest order is. I saw it happen to several people just today in Coweta Superior Court, and we've got to be vigilant in defending the citizens of Coweta County against an overburdensome government, and we're going to do everything we can to help keep the citizens of this county out of cages. So if you get an arraignment notice in the mail, be careful. Contact an attorney as soon as you can, whether it's me or somebody else. Just make sure you got somebody. Our website is www.jryanbrownlaw.com. Our phone number is 470-635-1725. Call us or text us 24/7. I don't even have a voicemail, so you'll always get somebody. 470-635-1725.